that you waited.
Hello, everybody. Welcome to Dad Talk Today. It's Monday night. We've got our live Q&A going on. I got Mr. Kevin Hickey with me. Kevin, what's going on?
Hey, hello.
Uh-oh, I lost him there.
Am I here?
There you are. Seems like we're
Hello?
having a little bit of connection issues.
Okay. Maybe we can get that wiped out.
All right, guys, it's a live show, so you know sometimes that can happen. Right before we get started, I'd like to say, if you're watching this now, make sure you like, share, subscribe, so we can get this message out to other people that might not know it exists. We'll be doing a live Q&A session tonight. So if you got some questions, put it down in the comments, and I'll bring them to Kevin. And we're going to talk about some of the things that people experience inside of family law. Nothing about this creates a client-attorney relationship. We're just here to try to give you some helpful advice. But Kevin, what's some of the things that are on your mind that would be good to discuss today?
Well, this doesn't come up every day, so I thought I would bring it up and talk about it. It really doesn't apply so much to family law, but it is something that's a current event that I think a lot of people are interested in. And that is we have a candidate for the Supreme Court that is going through what's called the confirmation hearings. And so I thought I'd talk a little bit about how someone gets onto the Supreme Court. As far as how Supreme Court justices are selected, well, the president is the first person that kind of starts that process. He's got a lot of people that work on it. But the president nominates a person whenever there's a vacancy on the Supreme Court. And that person then goes to the Senate and goes through what's called confirmation hearings. And that's what's going on right now with the current candidate. And the Senate will question the candidate on all kinds of issues, some of which are politicals. A lot of it deals with the law, cases that have been decided in the past, kind of what their theories are on how cases should be decided. And eventually, if there's a vote, and all it takes is a simple majority by the Senate to go ahead and confirm this person, then that person gets on the Supreme Court. And that's how it works. And it's set up that way. Everybody knows we have three branches of government. It's set up that way so that just the president can't just select a person on his or her own. The legislative branch gets involved as well. So the president is involved and can select the person, but then the legislative branch comes in and in a way has a little bit of a veto power. But by and large, when someone's been nominated, the vast majority of the time they get confirmed and get on the Supreme Court. Supreme Court justice, as most people know, their term lasts forever. As far as what the Constitution says, the Constitution specific language says that justices, quote, shall hold their offices during good behavior, unquote. And that pretty much means that they can only really be removed from office for impeachment, and that'd be by impeachment. That's about the only way they could be removed. If you're wondering if a Supreme Court justice has ever been impeached, the answer is yes. Way back in 1805, Justice Samuel Chase was impeached. The House of Representatives passed articles of impeachment against him. However, and we've seen this process work out in the presidency over the last 25 years or so. We've seen this a couple of times. He was impeached in the House of Representatives. It then went over to the Senate for a trial, and the Senate acquitted him. So he was able to stay on the bench until he died, actually, in, I believe it was 1811. So it has happened before. Doesn't happen very often, but that's how someone gets onto the Supreme Court.
All right, that's awesome, man. All right, we got a couple of questions. Mr. Dave Murray is going to start us off tonight. He said, Kevin, is there a difference between a level of immunity a judge gets and say a CPS worker get? I heard the term qualified immunity shot around.
Yes, and it gets a little bit convoluted, but judges do have more of what's called an absolute type of immunity. It's not 100%, but they do have a little more immunity than, say, a CPS worker would get. Qualified immunity is a level below, and that means there are certain things that a state agent, a state actor can do that they can not be, that they lose their immunity for. Usually it's when they're outside the scope of whatever their employment is. If a state actor is working within their framework, within the parameters of their employment, many times they have immunity, and you just can't sue them.
Angelina Barrera said, "Can you find out why a judge recused themselves?"
It's if the judge will tell you, and Angelina, I'm not being snarky there. The judges sometimes will recuse, and they will sometimes tell the attorneys why. But a lot of times they don't give reasons. Usually, a lot of people think there's some kind of conspiratorial or nefarious reason or sinister reason why they're recusing and what's going on and things like that. The vast majority of time, what's going on is the judge knows one of the parties, or a particular issue in the case is an issue that they either know a witness really well that's going to be a central witness in the case. There's some reason like that there's a relationship there with somebody that they're, either socially or professionally, that they are concerned might have what's called the appearance of impropriety. In other words, it may not look right. So they will recuse out of the case. But a lot of times they won't tell you. But most of the time, the judges that I've worked with, they usually say, "Hey, I know." They call both attorneys or send them a letter and say, "Hey, here's what's going on. I'm going to have to get out of this case," and they transfer it to another judge.
I get a little bit of a long one from Mr. Weekend and G. He said, when the court order 2 hours optional visitation, 1 overnight a week for the 1-year-old, do you think it's a good idea to take on myself, hire a professional provider from court-approved list to facilitate the exchange and supervised visit? I feel safer for myself to have supervised visits than going alone to her house to pick up the baby. Already lost 5 months of my time with the due to DVRO. X allegations, I'm hostile, and she's terrified of her life during exchange. Her temporary DVRO were denied.
It's going to depend on what it says you get 2 hours of optional visitation. It's going to depend what your order says as far as what kind of visitation you get, number one, and also how is that exchange supposed to take place. So whether you have a professional provider there or not, ask yourself, what are you needing a professional person there for? If you're just needing a witness to witness what happens and make sure that everything's okay, you can bring a family member, or you can bring a friend, or you can bring someone else that your attorney may recommend if you don't want to have to pay somebody to be there. And they can monitor what's going on. A lot of times I advise clients to either videotape or audio record the exchange to make sure nothing happens. Or if something does happen, you'll have a video of it. But if you've got an order and it looks like there may be that it's supervised visitation, you see what your order says and as far as what it says, as far as the parameters of who can be there, who can be at the exchange, who can supervise, and that may limit what you can do, or it may not limit what you can do, and you can pick pretty much whoever you want.
Kevin, talking about this supervised visitation, I know a lot of times, some of these guys feel like that's one of the things either they can't afford or that's a hassle. But have you ever seen it, with some of your clients where you might recommend that happening due to false allegations or something like that? Or what are some of the reasons why you would see that be necessary?
Yes. We have, yes, we've had a lot of situations through the years where there's been false allegations. And so to protect the client, we have suggested to the client, do you have a relative that can be with you all weekend for your visitation? Or do you have someone else that can be there that can monitor what's going on? Because, they're worried, and rightfully so, that as soon as they have unsupervised visitation and they're alone at home with their child, then all of a sudden, as soon as they go back, the other parent, especially if there's been alienation going on, is going to start quizzing the child, twisting things that they say, and somehow say that there was something negative that happened, some kind of abuse or something inappropriate while over at dad's house. So yeah, I mean, we have suggested before that have somebody with you until this kind of settles down, because we want to protect you. We, not that we're worried something's going to happen. It's just so that you can prove that nothing did happen. It's not just your word against the other parents.
Yeah, and while Weekend is talking about that, and guys, if you got any questions, put them down in the comments. We'll definitely get to them. We're a little caught up at the second. But, something I wasn't very familiar with until after John passed away, and we started doing this with the John Mast Foundation. There is something called the Supervised Visitation Network, where they have a list of providers nationwide. I think there's like 800 something providers, where you can do safe custody exchanges. If you feel like your life is being threatened, or that there might be some allegations of some sort, they have these custody exchange centers where you can pick up and drop off your kids. You and mom never come in any contact, and they have security and stuff there. I think we really need to start promoting that and letting people know that those exist. But I know a lot of times this needs to be court ordered. Is there something that you would recommend if one of these guys feel like that might be a service that they would need, and maybe some advice on how to get that set up?
Well, as far as getting it set up, make sure, talk to the facility first and make sure you qualify for using their services. More than likely you will, but find out how much it costs if you qualify for it. And if you do, you need to get with your attorney and make sure you get that put in the order that that's the facility you want to use. Now, the other side may object to that, but they need to have good objections and good reasons, or the judge will usually allow you to use whatever facility you want. So that would be the best, and the best way is to get it put in the order that that's where the visitation is going to take place. Now, sometimes you can, if you don't want to go back to court, or you're in the middle of a case and you just left court and have an order from a month or two ago or whatever, see if you can get the other side to agree. Have your attorney reach out to their attorney and say, look, he wants to use this such and such facility, and he wants his visitation, be here these days or times or whatever, which days and times work for you, and can we use this facility? A lot of times you can get it done by agreement. But if you can't, then the next step is to have it put in your order so that you've got that, and both sides are ordered to do it.
Yeah. Claire Bowles down here said, I did have somebody with me, and that person was accused as well. In these cases of false allegations, usually, it's in pertaining to the other parent. But do you see some of the family members and friends caught in the crosshairs as well?
It can be, but you start to get more people with you, and the other parent or whoever is accusing everyone, then that can start to backfire on that person pretty quickly. But yeah, I understand what Claire's saying there. I mean, just think about think about your exchange, where it's going to be, who you're dealing with on the other side. You don't want to have a situation where you've got several people with you and it turns into a real negative situation in a hurry. But that's the only thing I know to do. You can video it. If you have video, that can show how the exchange went. You can video the visitations. A lot of these, the supervised places that you're talking about, some of those facilities will video the visitation. Now, usually they need releases, or they need authority from the parents to do that. But that's a way that you can monitor what happened. We talk about John Mast's case a lot. The visitation exchange center in that or where the visitation took place, supervised visitation center, those workers there were incredibly detailed with their notes as to what was happening, what the children were saying, how John was reacting. And it gave you a very clear picture of what's going on. Not all visitation centers are that thorough. And so video can help if you're allowed to do that.
Yeah. So guys, if you got some questions, put it down in the comments. We'll definitely get to it. But while we're waiting on that, Kevin, I know we've probably went over this several times, but you never know when there might be a new face in here that's hearing this for the first time and they're not quite sure where to go. One of the big subjects that we talk about on the show is parental alienation. Maybe talk a little bit about what that is and some of the red flags that let somebody know, hey, this might be where it's heading in that direction, and some of the things they can do to protect themselves against it.
When you've got an order in place that talks about where the child or children are supposed to be, with you so many days and then with mom so many days, and the other parent, whoever it is, continually violates that or tries to shave into your time or take away time that's yours, or the children start coming back and saying, dad says whatever about you, just negative things about you, or you're supposed to have telephone visitation and it's not happening. These things are supposed to happen. There's an order in place and there's a procedure in place for a reason, and it's for the two of you, the two parents, to follow that order and make sure the children are with each parent and that you're not talking negatively about the other parent in front of the children. If those things are not happening, and the other parent, you're starting to see a pattern that this other parent is violating the order, basically not doing what they're supposed to do, not letting you see your children the way you're supposed to, then you're probably dealing with an alienation situation. That's parental alienation. Anything that's designed by one parent to try to alienate the children or put a wall between the children and that other parent usually falls into what we call alienation. Now, you'll hear all kinds of phrases out there. You'll hear parental alienation, you'll hear parental alienation syndrome, and there's a bunch of other, there's psychological diagnoses that are used to talk about it. All of it is really talking about the same behaviors. And that's what judges are interested in, is don't really care what label you want to put on it, but these behaviors are causing a problem between these children and that other parent for no good reason. And when we look to the heart of what's causing this, it's usually what we call the alienating parent. And the parent that's being alienated is usually called the targeted parent. So when you've got that going on and you're wondering what is going on and why is this happening, you're probably dealing with an alienation situation. And you can there is a lot of information on the internet about alienation. You can go to our website, kevinhickeylaw.com. We have a lot of information on there about parental alienation. And that's what you're dealing with. If you're dealing with an ex that is not following the order, not letting you have the time you're supposed to on a consistent basis, you're probably on the beginning stages of alienation.
Got a question from Mr. Smith Neal. He said, as a father of two, how do I get 50-50 custody or more visitation time? We have a mediation judge agreement for every second weekend.
All right, Smith, I'm not sure what state you're in, but you want to look at that first, because some states are starting to really recognize joint 50-50 custody, what we call shared parenting, are starting to recognize that more. You may be in a state that has enacted that recently. You never know. For instance, here in Arkansas, we got it enacted by the legislature last summer. So that's where I'd start, is to talk to your attorney and see how often that happens in your state. The next thing is, do you have a schedule? Do you have a work schedule that will allow you to be able to have a 50-50 custody time situation? If mom is working just as much as you do, there's no reason that you shouldn't be able to do a 50-50 custody time. If you are working more and she doesn't quite work the same amount, you can still work something out to where on your days off you have more time. After work you have more time. So you just have to start looking at ways to show the judge that there's really no reason for you to not have 50-50 time. Saying that you've got this mediated agreement, it says mediation judge agreement. A lot of times we'll go to mediation and come up with an agreement. Everybody signs it and then it's sent to the judge and the judge signs it. That may be what you're talking about. says for every second weekend. That is a typical visitation schedule when the other parent, in this situation, it'd be the mom, has full custody. Standard visitation, what we've called it forever, is usually an every other weekend type of visitation. If that's what you have, then I don't know if this was a temporary arrangement, temporary agreement. If it was a final agreement, there may not be anything you can do at this point. You might have to go back to court at some point in the future. But if this is just a temporary arrangement, then you need to start working on with your attorney, trying to figure out how to get a 50-50 custody arrangement at the final hearing.
Got a question from Miss Hope Wagner. She said, what would you do if a parent is a convicted murderer, but is still able to keep his parental rights?
Well, if he's a convicted, I mean, it would depend on where this person is. I mean, if they're a convicted murderer, I'm assuming they're in prison either for life or for quite an extended time, should be. If they are in prison, different judges react to that differently, whether they want to allow a child to visit while the person's in prison or not. They can keep their parental rights. It's up to a judge to terminate them. If on paper they keep their parental rights, but they're in prison for the rest of their life, I mean, I don't know, how practical it is for them to stay in that situation. That's an interesting question. I'd like to know if the person's like in prison forever or how that's going to go.
Angelina Pereira said, do you practice law in Texas?
We can. I'm actually co-counsel on a case in Texas currently. Our firm handles a lot of high conflict custody cases. We handle, which are usually cases that involve false sexual abuse allegations, parental alienation, CPS or DHS has gotten involved in the case. Those are the kinds of cases that we handle, and we take those cases anywhere in the country. And what we do is we work alongside your local attorney in your state. And a lot of people ask the question, well, you're not licensed in this state. How can you do that? We do get licensed for your case. There's a procedure called pro hoc vice, and we go through that process and get admitted through your state, for instance, in the state of Texas, to practice on your case in that state. And that's what allows us to be able to do that. It's a long answer, but the answer is yes. We can help on your case.
I got a question from Mr. Charles Fitzhenry. He said, my question is, when you have irrefutable proof that the other parent has conspired with numerous other parties to lie, disrupt, and frustrate to cause deprivation of your rights, what would be a beginning step in addressing this?
You'd need to go to court. If you don't already have a case pending, those are all serious things, and you'd need to file some kind of motion with the court to have it stopped, because the other parent sounds like they'd be in contempt. And along with that, you may have enough evidence to change custody. You'll just have to talk to an attorney in your state to see. But bringing those things up, about the only way you're going to get it to stop. You can start by having your attorney write a letter to the person or their attorney and say, look, she's engaging in this kind of behavior. It needs to stop, and or we're going to have to take it to the judge. And hopefully that solves it. But if it doesn't, your only real relief is to go to the court and present it to the judge and ask for the judge to do something about it.
I think we covered this a little bit earlier, but Wiki and NG said supervised visitation could be a good thing for a falsely accused father, ? Especially if the father asked for it themselves to avoid false allegations, reduce conflict at the exchange, having witness and supervisor submitting declarations to court. X isn't willing to cooperate with supervisor. X has conflict with supervisor. But I think in that case, if there's lots of false allegations and stuff going on and you're doing that to cover yourself, absolutely.
Yeah, definitely. And, he mentions there at the end, X isn't willing to cooperate with supervisor. X has conflict with supervisor. Sounds like they may have chosen somebody already. What we do a lot of times, the judges will say, I'm ordering supervised visitation. and I'm going to let the attorneys try to come up with a mutually agreeable person or a place to do that. And if the attorneys are not able to agree on it, then the judge will decide. And either way, whether the attorneys agree on a person or the judge decides, usually we put that facility in the order so everybody knows where we're going, what we're doing. So if the ex isn't cooperating with that person or has a conflict with that person, that's on the ex, and something needs to be done about that to make her understand or him understand that this is the person that's been ordered by the court to supervise the visitation. And you can be a person or not, but if they're not getting along with that person, then that's something you may need to bring up to the court, especially if you're going to have another hearing in the future. You want the judge to know how this totally neutral supervisor who doesn't have a dog in this fight is the mother is not getting along with her for really no reason. And so that's something you'd want to bring up in court.
Mr. Jamin Wheats said, so if we have restraining orders that keep people apart, do we have anything that orders people to come together and talk, since many human problems can be solved by sitting down and talking about it? And is it enforced if it exists? It seems odd if we don't, that we would only have restraining orders that keep people apart. I think it was a good question.
That's a very good question. As far as ordering people to come together and talk, most judges, at least the judges I deal with, if we're going to do that in a setting, it's usually going to be in a mediation. So I will usually talk with the other attorney fairly early in the case and see if they are okay with mediation or if they think this is a case that might be good for mediation. Because some cases are not what we call a case that's a good candidate for mediation. But if it is and the other side agrees, then that's a great place to talk. And I have had many mediations where my client has said, hey, can I just talk to her for a couple of minutes? And I say, well, let me go see. And we go ask the other attorney. And most of the time they're okay with it. And but mediation is a really good place. Once a case has started, is a really good place for that to happen. Now, and I don't know if this is in your case, you're talking about the restraining orders, but restraining orders are usually attached immediately to any divorce that's filed, because just history has told us that a lot of times divorcing people can be, acrimonious. There may have been some domestic abuse involved. And so the courts kind of nipped that in the bud and said, we're going to put these orders in place right from the day one. So everybody knows you guys cannot be harassing each other. And if you are, the judge is going to do something about it. Now, I tell my clients, if you can talk civilly with your spouse and work things out, then do it. But if every time you try to talk about your case or some kind of settlement, it just devolves immediately into an argument, then let the attorneys handle it. But mediation is the biggest place and the best place to try to get parties to come together and talk once a case is started.
Mr. Adam Hernandez said, mother put in court order that daughter has right to deny visit when daughter wants to, but my daughter is only 16 years old and in the state of Texas. I believe you have to be 18 to deny parental rights. Will this hold up when we go to court again?
I'm trying to see, Adam, you said she put it in the court order. I don't know how that happened. I'd like to know if that was an agreed order, if you guys agreed to that. Most judges hate that kind of thing because it puts the decision making on whether visitation is going to happen or not entirely in the child's hands. And they don't want to do that because then the child's in the middle all the time. And most judges feel like if visitation's ordered, the child needs to understand that visitation's going to happen. So when you put something in here like this, it can cause a problem. Now, I will say we've had situations where we have put something like that in the order, but it's a really unusual situation. There's a poor history there between that parent and that child. Either they've never gotten along or there may have been something that happened in the past. And the child many times is older. They're 17 and a half, and in a few months they're going to be an adult, and they can do whatever they want at that point. So there have been some limited, unusual situations like that where both sides have agreed to put it in there. So I don't know if this is something you agreed to. It doesn't sound like it is. Most judges are not big on those kinds of provisions.
He commented down below and said it wasn't something he agreed to on that.
I'm surprised the judge put it in there, because that's not something usually a judge puts in on their own, but there could be a lot of reasons for that.
Winton Morrissey said, my daughter's mother has me in civil court for my parental rights. How long does those type of cases stay open? It's been 3 years already and no court date.
Winton, tell me a little more about that. I mean, I'm assuming you're saying that it's maybe a paternity case for you to be declared the father, or they might be trying to terminate your rights. I'm not sure. Usually 3 years is a very, very long time for a case like that to go without having a court date. I don't know what's going on, but that's a long time.
Yeah. Hey, yeah, man, if you will get that down in the comments, and we will definitely get that pulled back up. I got a comment from Auntie Dino on YouTube, said, is there any case against administering supplements as medicine to the child? The particular supplement is legal, but medical journals and case studies all point to it being dangerous to ingest.
I don't know what the answer to that is. Judges always look at every case differently, because every parent is different, every child is different, every situation is different. So in that situation, I think you're going to look at what are the supplements? Does the child have some kind of particular diagnosis that could benefit from these supplements? Are there any peer-reviewed medical journals? And I know you've mentioned some here, but that talk about that it's really helpful for a child with this diagnosis to be on this medication. But if it's dangerous to ingest, if I'm a judge, that's going to be a big red flag for me. The first thing on any of this stuff, any medicines, whatever, and that goes all the way back to the Hippocratic Oath, which is first do no harm. And if something's dangerous to ingest, that causes kind of a red flag for me. But every case is going to be different, and you just have to present it to the judge and explain why it's so important that this child have this supplement.
Yeah, that just brought up something, and I definitely agree when I hear you saying this, but there's going to be times where judges are going to react completely different than another judge would. I was just curious, what are some of those instances where you see they really have a different opinion and not something that's always said?
Well, that's one. That's one situation is medications. But usually they will side with, we will either bring in a pediatrician or the doctor to talk about what the reasoning is. And usually the judges will side with that. Other things are what's medically necessary. One big argument that parents end up getting into is orthodontics. Once a child gets closer to teenage years and needs braces or doesn't need braces, those are expensive. And a lot of times they're not covered by insurance. And so we see parents arguing over that. One parent will say it's not really necessary. I never had them. The other parent will say, oh, well, we need to do it. So you can get into and I see judges go all over the map on that. Usually if a dentist or an orthodontist is saying these are needed, even if it's iffy, a judge is going to decide with that. Another thing where judges can disagree is on counseling. Some will listen to a counselor and believe, everything they're saying and what's best for this child. And I've had the same counselor go in front of another judge, and that judge thought this counselor didn't know what they were talking about. So that's another area where you can see differences in how judges handle things.
Yeah. Adam said, I got to comment, I've not seen my daughter since in about 4 months. We had a great relationship, no problems. Now mother says I'm giving her mental issues and I really just want us to get family counseling. But mother denies me that. also and clearly states on court order that I have the individual right to seek her help, the medical and dental. Is that something you see where, they can request, family counseling and right or
Well,
asking to get the medical and mental?
yes, absolutely. And Adam, the way I'm reading that last part is that the court order says you can decide if your child goes to it looks like medical or mental treatment. So if you think that's what she needs to talk to someone, have her talk to somebody. And I know you mentioned family counseling. If your case is ongoing, or really if it's not, I guess you could file something with the court to have it re-examined. But if you think family counseling would help, judges will listen to that. You just need to bring it to their attention, and you got to show them why you need it. You got to show them why you think it's going to be helpful for everyone involved. And the way you do that is talk about some of the problems that you've seen, some of the behaviors you've seen from your daughter, and why you think a family counselor would help with that. And I think if you do that and talk with the judge about it and really explain why it's needed, I think the judge will be sympathetic to that.
Mr. Charles Fitzhenry said, expanding on my earlier question regarding numerous parties conspiring to deprive me of my rights, I have written letters compelling specific individuals to keep within constitutional limits. I have also reported this activity to numerous agencies, and many of the pieces of evidence proving the deprivation are in court and under oath statements and admissions. At what point do state and federal lawsuits come into play, and how complicated might this be, pro se?
I'll go to the very end of the question first. It's incredibly complicated, Charles. And if you're going to try to file a federal lawsuit or even a state lawsuit talking about constitutional issues on your own and you're not an attorney, it's very, very difficult. And that's something you really need to think about. You're going to need transcripts. You say you've got under oath statements and admissions from either depositions or hearing testimony. You're going to need to get copies of those transcripts, and you'll have to talk to the court reporter and pay for those. But lawsuits, of this type, you really have to have a solid cause of action as to why you're asking for it. Private lawsuits about having your constitutional rights violated, those are rare, and they're hard to win. So you're going to really have to have your ducks in a row to get very far with it. You might find an attorney in your area that handles some civil rights cases, and if you're really serious about going forward with it, you may want to just call them and say, I need 1 hour of your time. And what I need to pay you for 1 hour of your time to talk to you about this and get some answers. Run everything by them and have them give you some advice on if they feel like you've got a case or not. That might be money well spent.
Miss Carmen Vinoy said, is there a group like this for mothers?
Yes.
I'm not too sure. But I tell you, if you're a mom and you're watching this and you got a question, put it down there. We're not against moms by no means. We're against, we try to raise awareness for some of the tricks that can be played where men are involved, and victims from mothers that play some of these tricks. But if you got something in here, please ask it. We're here and we just want to see, solutions for the whole family. Even though it's called Dad Talk, you're more than welcome. And, anything you got, bring it to us.
We have lots of moms give us questions.
Yep, absolutely. CA Liberty on YouTube said, when filing for emergency custody, is the child's claims of abuse enough evidence? I did contact the police and interviewed myself and my son, then conducted an investigation and reported it to CPS.
That first question it's all over the map. When filing for emergency custody, is the child's claims of abuse enough evidence? It depends. How old is the child? What are they alleging happened? When you listen to them tell their story, is it the same every time? Does it sound credible, or does it sound incredible and strange and kind of like a fantasy world? There are all kinds of things that go into trying to decide, that a judge will consider when they get an affidavit from a child and they're reading this, trying to decide whether they think that's credible or not. And is it enough abuse or enough evidence to get emergency custody. Most of the time, after what's called an ex parte order is entered, that's when the other side is not present and the judge just signs an order. Most judges will try to set that hearing almost immediately, as soon as they can after signing such an order, because they want the other party to come forward and be able to give their evidence. So it can be, absolutely. We have had, children give affidavits and come and testify in emergency custody situations, and it absolutely can be enough evidence. But every case is different, and every child is different, and everything that they talk about as far as what they've observed, what's happened to them, as far as their environment at home or whatever, that's all different every time. And I'd have to really listen to what the child had to say to give you a better idea, but it can be enough. It sounds like you've already taken the proper steps, which is going to the police. You've been interviewed. Your son's been interviewed. It's been reported to CPS already, so they'll do their investigation, and then you'll just have to see what they come back with. If they come back that it's founded, or they think there's definitely something there, you'll want to use that in your emergency custody hearing.
I got a little bit of a long one here from Mr. Eric Smith. He said, I am filing another contempt against mom in North Dakota. She's blocked my number, etc. I live 200 miles away, but I'm now going to sue her for parental alienation, and there is enough proof to win the civil lawsuit. Fargo, North Dakota, Cass County. It will be another pro se contempt, but this time I'm also filing for indirect criminal contempt under North Dakota Century Code. Luckily, I am a law expert, because if I was not, I would have been railroaded long ago. All this will be her, I believe, 6th contempt. I'm going to hold the judge's feet to the fire. If I don't hold her feet to the fire, I will lose. I usually only get sanctions on her if I literally make sure they follow the law as it is written. Any thoughts on that, Kevin? I thought there was a question in here, but I'm not really seeing it.
Yeah, I'm not really seeing a question either, but that's just sounds like, Eric, you're doing everything you need to be doing. And I know this will be the 6th contempt. You just have to impress upon the judge that apparently nothing's getting through to mom, and something more's got to be done. I don't know if I know you said she's had sanctions against her. I don't know if some of those included jail time, but it may be time for her to go to jail for a few days. We talk all the time on here about judges put orders in place because they want them followed. And when they're not followed, and all you're coming back to court for is for the reason that they're not being followed, judges aren't happy about that. So especially if you've already had 6 contempts against her, I got to imagine this judge is getting tired of having this person in front of them, and it's time to do more. Either put them in jail or change custody. I don't know if custody's been changed or not, but it may be time for that.
Question from Andrew Sagini. He said, if a judge in one state made the final order in the divorce and the mother moves to another state, can another judge modify that court order regarding visitation, or does it always revert to the judge that made the original order? Are they the only ones that can modify the original order as far as custody?
This is a great question, Andrew. And if you want to read more and want to do it late at night and fall asleep, you can look up what's called the UCCJEA. UCCJEA. And I'm going to see if I can get it right. It's the Uniform Child Custody Jurisdiction Enforcement Act. UCCJEA. That governs situations where someone's either divorced or there's a custody determination in one state, and then one or both parents and the child move out of that state to another state, and then there needs to be legal proceedings again to either change that order, modify it, something like that. A lot of laws come into play, a lot of, I should say, requirements come into play as to who has jurisdiction at that point. And that goes to the question that you're asking, who's going to be able to modify that order? The simple rule is the judge that had it, the court that had it, will keep jurisdiction of that case, and you'll always have to go back to that court to get that order changed unless you get it changed to the new state. If one parent is still living in the original state where the order was entered, then more than likely that state's going to keep the case and it's going to stay there. If neither parent lives there anymore, then it's going to probably get moved. There's a good chance it'll get moved to one of the states where the parents are living now. It gets a little complicated when both parents move out of that state and they don't move to the same state, like one moves to Texas and one moves to Nebraska. You open that case again, which state are you going to move it to? A lot of times the judges will move it to wherever the child is residing most of the time, but that's not always the case. But to go to your final question, no, they're not always the only ones that can modify the original order. But if one parent is still living in that state, then more than likely the case is going to stay there. It gets really complicated, and more than likely you'll need to talk to an attorney at some point about where your case is going to end up, whether it's going to stay in that state or it's going to go to the new state.
Auntie Dino on YouTube said, "Thanks, Eric and Kevin. I typically don't get a chance to catch these live, but I watch them all. Is there anything unique about a final pretrial from a typical pretrial hearing?"
Every judge handles pretrial hearings differently, so I can't really answer that. Pretrial hearings a lot of times are set up very early in a case. And usually a lot of times that's just for, like when we have pretrials around here, it's for the judge to say, okay, how long are you guys, talking to the attorneys, going to need for discovery? How long do you think a final hearing is going to be? Are there any motions that need to be filed? It's really just kind of a scheduling, let's keep this on track to-do list for the attorneys and the court to keep that case moving along. Final pretrial before a final hearing, if you've already had one pretrial, there might have been a lot more issues that came up and that the judge is wanting to address before you go to the final hearing. Judges' dockets are crowded, and when they set a case for an entire day at 9 o'clock, they want to start at 9 o'clock. They don't want to take the first 30 minutes or an hour dealing with all these little issues before they get to their hearing. So if they get concerned that something like that's going to happen, that may be what you're talking about. The judge may have set another pretrial before your final hearing to try to wrap some of those things up. That's the best I can think of.
Carmen Vinoy said, "I am a single mother. My children's father abandoned us over 6.5 years ago and does not pay me child support as the judge ordered him to do. Almost 3 years ago, there was some family drama and my parents made allegations against me and took my children from me. And all of the time, they have been unable to prove that I did anything wrong. This is a private matter that has been addressed only in civil court. I've had 5 different attorneys who have looked at my case, and they all agreed that what my parents did was illegal. Typically, one has to provide extensive evidence of wrongdoing before taking children from their mother. My parents offered absolutely none. It has been over 2 years since my last court hearing. I cannot afford a private attorney at this time. What can I do?"
Well, you're going to need, if you can't get an attorney to help you, if you want to file something you're going to have to file something with the court to get any of this changed. I don't know how your parents got custody. I don't know if CPS was involved. Now, it says civil court, so that makes me think that it wasn't CPS or DHS, because that's usually a juvenile court case. So I'm wondering if her parents got guardianship, could have filed for that. A guardianship can be ended at any time. You've got to just file to have it terminated. If you can't afford an attorney, you may have to do that on your own. It's not an easy process, but it can be done. But you'd have to file something with the court to get that changed.
Mr. Brian Stark said, "What is a good argument to why you have not paid for judgments? I lost for their attorney fees. I cannot file a motion until fully paid. In short, I failed regardless. I have attempted to pay them, but they refuse payment. I am not wealthy, so it's hard. They never send me a bill. This is debtor's prison. The order puts the children at risk, etc."
I'm trying to put that together.
Sounds like he has not been able to pay for the judgments, and I guess the ex was awarded attorney fees.
Well, that's what I was thinking, but then he says he attempted to pay and they refused payment. So
I didn't understand that one either. I don't know why they would refuse.
Well, debtor's prison, I can kind of talk about that a little bit. A lot of people get held in contempt of court and they're ordered to pay attorney's fees and they can't, or they need it paid or something. One of the arguments we hear is, well, you can't put people in prison for a debt. We all know what debtor's prison is, and you can't do that. Well, a contempt finding that is a sanction is more of an order of the court. So it's not really a debt in the typical sense, a civil debt. It is a court cost. It is a court fee that's been assessed for a sanction or some other reason. And you can be held, if it is for contempt, you can be put in jail for contempt for not paying it. So I'd like to know more about attempted to pay it and they refused it, because if you're trying to pay it and they're refusing the payment, then, that's a problem. I don't know why they would be refusing that when it's been ordered that you pay them. So.
Yeah, Brian, if you could answer that last part for Kevin, because I'd like to know that as well. But he did put down there, that's what it was. She was awarded the attorney fees, but I don't understand why they wouldn't take the money from you.
We've been ordered. We've won judgments to get our fees or partial fees paid for lots of times through the years. And anytime someone wants to come forward and pay part of it or whatever, and then pay we try to work with. I don't know what that is.
Yep. Jonathan Zarco on YouTube said, mother continues to not take kids to school. They are in pre-K, but absences are unexcused. What can I do?
That is something, Jonathan, this kind of goes to the heart of something that we deal with a lot in custody cases when we're asking to change custody. One of the things we get medical and all of that stuff, but one of the things we always get is the school records. And I always want to know three things: the child's attendance, the child's grades, and the child's behavior. A lot of times you will see something wrong with one of those three areas, if not all three. So absences are something that a judge definitely wants to look at. If it's a handful of absences throughout the year, and some of them were unexcused, a lot of judges don't get too upset about that. But if there is a consistent pattern of missing school, a judge is going to have a problem with that. Now, enough of a problem to change custody, not necessarily, but as far as what you can do, you need to talk to the mother first and say, look, I'm noticing all these absences. This is an issue and it needs to be corrected. And if it's not, then you may have to file something with the court to either have her held in contempt or have something done, because I think everyone knows this, if you get enough absences, that child gets enough absences, you're going to start getting CPS involved, or the local juvenile court's going to get involved, and you're going to start getting some attention that you definitely don't want. So I would address it with the mother first, and if she's not going to fix it, then you may have to get some kind of legal relief.
So Brian is saying, I was trying to pay it, but they continue to refuse it, and he believes that so he can't file a motion.
I don't know on that.
That's a new one. I haven't heard that one, brother.
Well,
I would like to know, what is the reasoning? What are they saying to you for not, when you try to pay them? How are they?
Make sense.
Yeah, because I would think there should be something you could do about that. Winton Morrissey on Facebook said, can an attorney have a child support case tied into a civil suit in Texas?
I'm not sure about that, Winton. That's more of a Texas law issue. This brings up an interesting point, though, and this may be what he's getting at. It is very rare, but many times you can have a domestic case going on, and then there's some kind of civil lawsuit that could be filed against the other parent too. Either some kind of, not necessarily personal injury, but some kind of cause of action, defamation, whatever, that you can sue the other parent for. And sometimes I've heard of situations where you get these cases that get combined. It's a domestic case, which would be like a child support case that Winton's talking about, combined with some kind of slander lawsuit against the same person. And so you can combine them and have your hearing, your trial, all at the same time. So I suppose it's possible, but I just don't know the answer to that as far as Texas goes.
Yeah. Carmen came back in here and said, in my case, no, CPS did not take my children. Rather, my parents paid some people off to take my children from me. Yes, I have proof. There is a great deal of corruption in my local court system. My parents are wealthy. I work, but I don't have nearly as much income as my parents do. Someone that my dad paid off got up in court and alleged that I had beaten my son. The judge promptly referred the case to CPS. A representative came, interviewed me, my children, and my parents, did a home inspection, and told me she was closing the case as she had no concerns and found no basis for keeping my children from me. That was nearly 3 years ago, and my parents still refuse to return my children. I mean, what would you say are some of the steps that Carmen should be looking at if that what she's saying in that comment is how it's going?
She's got to go back to that court. There is a court order somewhere giving those parents custody. There has to be. If not, then they're violating the law by keeping those kids. So there's an order somewhere, and your first step is to go back to that court that issued that order and get it changed. And that's all you can do. There's something giving them authority to keep those kids, and you just got to figure out what court that is and what that order says, and go back to court and have it thrown out. That's all you can do.
Yeah. Well, guys, I think that brings us to the end of the show. Kevin, do we have any updates on the John Mast case as of lately?
This very second, the trial is still set. This is Jim Bashir's trial, is still set for the week of May 16th. But don't make plans to go out there if you've been making plans to go out there, because I think it's going to get moved. We're having a meeting. Won't talk more about it, but later this week I should know more about what's going to happen, and we'll try to announce that. And I'll try to get you the info, Eric, so you can put it on the Dad Talk page, because I think it's going to get moved again.
Yep. Adam Hernandez had said something earlier, and you asked for further clarification. I can't remember. Yeah. I'm going to read the comment. Maybe it ring a bell. He said, looking over the court order, it has boxes that were checked and then altered with whiteout. Same page that mother hand wrote that daughter can opt out of visits. Should I also bring this up when we go back to court? I think this was it the one talking about the mental and the medical?
Maybe, yes. But then also the first question he had was that the daughter has kind of the control on whether she can go to visits or not. Yeah, okay. I'd bring it up. And especially if surely she didn't white that out on her own and give that to the judge to sign somehow. That's definitely what we call fraud on the court. And, but yeah, you need to definitely bring that up, that needs to be changed.
Yeah. Charlie's Basdane said, go Arkansas. Good luck in the Sweet 16, sir. Go Hogs. Love you both. And thank you for all you do.
Yes, sir. We're going to take down Gonzaga, man.
Is there something going on with Arkansas right now? I'm behind in my sports.
Hey, we're in the Sweet 16. Yeah, the basketball team's doing great. We got a great coach, Eric Musselman, and they are in the West Regional out in San Francisco. They play Thursday night to play the #1 team in the nation. So we need to get them some support. So
there you go, guys. Well, Kevin, I appreciate you as always coming on here and answering everybody's questions. If somebody would like to get your services or talk to you, how can they reach out to you?
They can call our office at 479-434-2414. That's 479-434-2414. Our offices are in Arkansas. Our primary office is in Fort Smith, Arkansas. You can reach us at our website. It's www.kevinhickeylaw.com. That's kevinhickeylaw.com. We have a lot of good free information on there, as I said earlier, about alienation, CPS cases, false abuse allegations, all kinds of divorce, custody, all kinds of stuff. There's a lot of free information on there for you, and you can find us through there. We take cases all over the country, and the bulk of what we do is custody cases, and we take high conflict custody cases. We will be admitted to practice in your state for your case, and we work alongside your local attorney. So if you think you want to bring us in, just give us a call. if you'd like us to consult with your local attorney or just work as a consulting attorney throughout your case, we can do that too.
Yeah, we got somebody requesting you put your contact information down in the comments. I'm sure he'll get to you as soon as we get off the show. One last minute question, and God, I hope I say your name right. If I don't, I apologize. It's Cephalosha Black. He said, I don't have a lot of money. Can I get free legal representation in Florida?
Every state's different. You know, some states have more funding than other states and can provide some services where they give free legal representation. You know, the best I would know to do, I don't know of anything in Florida, I'd tell you, but the best I know is maybe Google that in the Florida area where you are and see if there's anything like that down there.
Yeah. And Seth, just so you're aware, and anybody else that's watching the show right now, you know, we got the 50-50 passed in Arkansas last year. It is on the governor's desk in Florida right now. It went all the way through the House and the Senate. All he's got to do is sign off on it. So
I didn't know that.
Oh, yeah. Make sure you're calling Mr. DeSantis's office and letting him know that you are in support of that bill. I believe there's several states that are on the tipping point right now, but Florida is the closest.
Wow.
Yep.
That'd be something.
Yes, sir.
Yeah.
Well, guys, we will be back in 2 weeks from now on Monday and 8:00 p.m. We will see you then. Kevin, thank you, sir.
Hey, as always, good time. Thanks.
Hey, everybody. Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also Super Chats, patreon.com/DadTalkToday, and other ways you can support our channel. Thank you for being here, and we will see you next time.